chat section first of all. I need confirmation from all of you first of all, huh? Okay, so now I can see. I think I am now live. Let me check myself as well first of all. Yeah, I think I am now I am live. Okay, that's good. Chalo. Let's start the session now. So I think there was some lag before. Okay. So let's directly jump to the first question, and we are going to have 10 questions today, right? And I want everyone to be participative in this class. Okay? And see, in the Companies Act 2013, or for that purpose, whenever you are doing company law or whenever you are studying company law, it don't get disheartened when you are not able to attempt a question correctly while you are doing the practice. Why? Because see, most of the part in the company law is theoretical in nature, right? So it might happen you don't know the answers, right? But you have to intelligently guess it. And as we will move ahead, you need to remember each and every fact with yourself. Okay? Okay, the first question is, Stone Private Limited incorporated on 31st of July 2016. Okay, I have started to get the answers in fact. Don't worry. Chalo, just relax and let's read out the question in a very efficient and effective manner, then give me the answer. Okay. Stone Private Limited incorporated on 31st July 2016, and the meeting of the board was held on 1st October 2016. Is this violation of 173 section of Companies Act 2013? So what happens now? Key, when a newly company is incorporated within 1 year, within 1 month, in fact, okay, I think I have a question in the beginning itself. Sir, what's the most effective way to remember the sections and facts for Companies Act? See, you have to use your logic. Key, why there is a sometime you have to use the trick, and when no trick is basically useful for you, you have to mug it up, right? This is the only way to remember the facts. And as far as section number is concerned, you don't need to remember each and every section. First of all, everyone should pay attention here ki you don't need to remember each and every section, but inside this section, what is the provision, what is the penalty amount, what is the number of days, that you must remember from the examination point of view, right? Okay. So when a newly company is incorporated, what happens? Ki within 1 month, company has to do a meeting, board of meeting, right? So the question says Stone Private Limited incorporated on 31st July, but the meeting of the board was held on 1st of October. Instead, it should have been held within 31st of August itself. So yes, it is the clear violation of section 173. So the answer would be option number D. Okay, so okay. So Shubham is incorrect here. Don't worry. Koi baat nahi. If you don't know the answer of these questions, don't worry. But just remember, with each question, you should always remember that now you are, if the same question is repeated in the examination, you would be able to do this question. That is necessary in the Companies Act. With each and every question, you should remember the facts. Okay? So let's read about the section 173 in detail. So every company shall hold the first meeting of the board of directors within 30 days of the date of its incorporation. Okay? Yes, it is applicable for the private company as well. And therefore hold a minimum number of, see, one more question I have brought you. See what is written here. Thereafter, this question can also be asked now. So I have asked you this question about the number of days within which first board of directors meeting should be held. But see, question could be asked from this criteria as well, that after this first meeting, they should hold a minimum, or you can say ki in a complete year, minimum number of 4 meetings of its board of director should be held every year. So the next question might be like this, ki in a single year, what is the minimum number of board of meetings that must be held in a company? So the answer would be 4 meetings, right? And one more important thing is here. What is written here? In such a manner that not more than 120 days, that is your 4 months, not more than 120 days shall intervene between 2 consecutive meeting of board. That means ki the time duration between the 2 meetings should not exceed 120 days, right? It should not exceed 120 days, that is your 4 months. So within these 4 months you must have 2 meetings. Okay, so any consecutive 2 meetings should not have a difference of 4 months or more. Remember this point as well. This question can also be asked in the examination. Okay. Now the second point is, which of the following is true? First statement, NCLAT, that is National Company Law Appellate Tribunal, is the appellate tribunal for hearing appeals against the order passed by IBBI, that is Insolvency Bankruptcy Board of India, under section 202 and under section 211 of IBC. So basically it is asking you कि when this IBBI pass any order under section 202 and 211 of the IBC, right, Insolvency and Bankruptcy Code, it is IBC. So can the aggrieved party can order or can appeal against these orders in the NCLAT or not? So the answer is yes, they can appeal it, right? So basically it talks about the appeal of the order passed by the IBBI. So it is correct, yeah. Second option says audit committee is responsible for change of overseeing financial reporting and disclosure, charge of overseeing financial reporting and disclosure, such as reviewing of the financial statements. Yes, they do so. So audit committee is basically there to review all the audit work and as well as to review financial statements and evaluation of the auditors of the company. So it is also correct. Second option is also correct. Third option is audit committee is responsible for the appointment of director. No, it is not correct, because audit committee has nothing to do with the appointment of directors. Okay, so the correct option would be 1 and 2, but option number C. So let me check. Okay, so everyone has to guess, huh? Okay, Shivam is right, Dhaval is right. Okay, even if you're wrong, okay, don't worry about that. You have to tell me in the chat section ki according to you, logically, because you have to use the logic to come to the conclusion ki which options are correct or not. See, Companies Act is the most scoring subject in the examination. If you know something, you know, or when you are remembering it, when you are remembering the provisions or clauses, through the logic you can remember it. Okay, so you have to use your logic, you have to use your intelligent guesses. So you have to give me the answer, everyone. If it is wrong, don't worry about that. I'm not going to take out the names of the wrong ones, right? Okay, don't. And even if you are right, I'm not going to take out the names. I will say most of the people are correct or wrong. Okay, don't worry about that. Chalo. So these options are true. We have discussed that. So as per question number 3, as per section 124 of the Companies Act 2013, the company shall, within a period of how many days? So now section 124, we are going to talk about 124 in detail in this class only. Don't worry about that. But inside this section 124, we have a question here. Okay, only one minor detail. It is asking within a period of dash days of making any transfer of an amount to the unpaid dividend account, prepare a statement that contains the names and the addresses and the unpaid dividend to be paid to each person and place it on the website. So basically it is asking you कि when you have transferred your amount that is to be given as a dividend to the unpaid dividend account. So after transferring it to the unpaid dividend account, after how many days of making this transfer, you need to prepare a statement containing all the names, all the amounts and place it on the website. Within how many days after the transfer of the amount you should be doing that? So let me check. Okay, that's good. So the correct answer here is option number B, that is 90 days. Now it is only a one question in the section 124. There might be various questions that can be asked from 124. So let's do this 124 section in detail. So what does it says? So I have prepared this PPT for you, so that, see, one thing I want to tell you, okay, this 124 section is very, very, very important from the examination point of view. Okay. See, if I were the examiner, I would have definitely included a question from the section 124. I can say it is the most important section, right? Why? Let's read it out, then you will find out. Section 124 subsection 1 says, where a dividend has been declared by the company but has not been paid or claimed within 30 days. First question you have is this. So they must company is required to pay the dividend within 30 days. So if they have not, if they haven't paid the dividend or it has not been claimed within 30 days from the date of declaration to any shareholder entitled to the payment dividend, the company shall, see what is written here, within 7 days from the date of expiry of the said period of 30 days. That means after the declaration of dividend, 30 days has been lapsed. After this 30 days, if within 7 days, or you can say within 7 days from the expiry of this 30 days, company has to transfer this amount to the unpaid or unclaimed dividend account, a special account maintained by the company. Okay, so overall within 37 days. So you need to look at the question very carefully in the examination. If the question is asking you about the 7 days, so most probably the question would be asked from the 7 days only. Okay, so after the declaration of dividend, 30 days has been lapsed. After this 30 days, within 7 days, company has to transfer this amount to the special account, that is unpaid dividend account. Now after transferring it to the unpaid dividend account, what is going to happen? The company shall, within a period of 90 days of making any transfer, so after transferring the amount, within 90 days, the question that I have asked you, within 90 days they have to prepare a statement which is going to contain all the names, all the addresses, all the amount, and they have to place this statement on the website or any other place where central government has approved. Second question can be asked from subsection 2. Another important subsection is subsection 5. What does it say? Any amount transferred to the unpaid dividend account of a company in pursuance of this section, that is 124. Now it says which remains, in fact it has been asked in the previous examination, which remains unpaid or unclaimed for a period of 7 years. This has been asked previously in the examination. Which remains unpaid or unclaimed for a period of 7 years from the date of such transfer. Okay, so from the date of transferring the amount in the unpaid dividend account, if 7 years have been passed, okay, or more has been passed, then they have to transfer it. They have to transfer it as per section 125 subsection 1. Sir, what is this 125 section and subsection 1? We are just now talking about 124. Why are you telling us section 125? Because it talks about the investor education and protection fund. Don't remember the section number, but remember this thing, ki if 7 years or more has been passed after the transfer of the amount, then they have to transfer it to the IEPF, that is investor education and protection fund. So the full form could also be asked from you, that is IEPF, or the time period, that is 7 years, can also be asked from you. So these facts you need to remember. Okay? Now the question number 5th. Let's move to the question number 5. It says Mr. Ganesh has been a judge of important questions. So again, NCLT and NCLAT are the important sections, right? The chapters which relates to the NCLT and NCLAT is the important one from the examination point of view. Mr. Ganesh has been a judge of High Court for 10 years. Is he eligible for the post of President of the National Company Law Tribunal? Yes or no? So yes, he is, and I can see, okay. So basically, yes, he is eligible for the post of President of NCLT, and let's read out the other provision as well. Okay, so it says what is the exact provision for the appointment of the President for the NCLT. Let's read out that. So as per section 409 of the Companies Act, a person who is or has been a judge of High Court for 5 years, so you need to remember this thing. If he has been the judge of High Court for 5 years, he is going to be the eligible for the post of NCLT, for the post of President of the NCLT. Okay? Yeah, okay, that's good. Chalo, I can see most of you are correct here. Okay. Question number 6 says, which of the following is true? As per section 149 of the Companies Act, remember, every company shall have a minimum important question. Again, very important question. It can be asked directly in the phase 1. Every company shall have a minimum number of 2 directors in case of the public company. Is it correct? Is it correct? Okay, so I haven't got the answers, don't worry about that. Okay, so it is not correct. So every company shall have a minimum directors, every public company shall have a minimum of 3 directors, not the 2 directors. 2 directors limit is there in the private company. Okay? No individual who has already been allotted a DIN under section 154. Even if you don't remember the 154, don't worry about that. No individual who has already been allotted a DIN is director identification number, shall apply for, obtain or possess another DIN. So this is absolutely correct. So just like we have the PAN, we can't have more than one PAN, or we can't have more than one Aadhaar, just like we have the director identification number. So every director has been given, or they have been allotted a director identification number. So no individual should hold more than 2 DIN. Okay? So it is absolutely correct. Third option says every company can have maximum of 20 directors. Absolutely incorrect. So we have been asked about the true statement. So the option would be option number B. So let me check. Only 2 would be the answer. Yeah, okay, that's good. Okay, very good. Chalo, I'm really happy to see this, but I'm not going to take out the names because it is company law. Even if you don't remember, you are here to remember the facts. Even if you don't know, that is not a case of worry. Okay, so okay, I will ask you a question again. What is the limit of the maximum directors? Tell me. The question says every company can have maximum of 20 directors. So I think I got the answer. No. So tell me, if every company can have how many maximum directors, apart from the exceptional case or the special resolution case, but generally, what is the maximum number of directors that are allowed? Tell me. Okay. So the answer is, okay, I have not got the answers. The answer is 15 directors. Okay? So as per the Company Act, 15 directors has been allowed maximum, but it can exceed to any number of directors, or it can be increased through the passage of special resolution, or if it is approved by the government. But 15 directors has been stated in the Companies Act. Okay? Okay. So the question of this answer was option number B. We have discussed that, but I have given you another information as well. Okay. Yeah, Mukul is correct. Vipin is also correct here. Okay, very good. I'm not going to take out names. Okay. Okay. So I forgot that. Okay, chalo. Question number 7 says, so each and every question, I am repeating this, you have to remember fact with each and every question. Okay? That's why we are practicing it. That's why I am making sure that you have the information with you that is required for the examination. Small shareholders are the shareholders with shares of nominal value less than or equal to what? So I have started to get the answers. That's very good. Okay. So tell me what should be the answer here. Small shareholders are the shareholders with shares of nominal value less than or equal to. So the correct answer here is 20,000. So if you hold the shares of Reliance, suppose less than 20,000 of rupees, less than rupees 20,000 of the shares you hold of Reliance, so you will be called a small shareholder. Okay? That is correct. Okay. So I can see most of you are correct. Okay. Very good. Now, and the section is as per 151, but don't worry about the section number. Okay? Only 1 or 2 questions would be asked on the section. Even if you don't remember that will be okay. But the rest of the information you must remember, like penalty, days, all the provisions. Okay? Okay, don't worry about the section. Okay. But only the important sections are you need to remember, like 124 section we have. Question number 8 says, which of the following is true regarding the financial statements? Very easy question. Financial statements shall give true and fair view of the affairs of the company. Yes, absolutely correct. Comply with the accounting standards as per section 133. Now, this section is also important. So see, 133 is important. You need to remember this section. Okay? Because as per this section only, companies need to comply with the accounting standards. Therefore, this becomes important, right? And 124 is also important. Now, option number 2 is also correct. Option number 3 says, it shall be in the form of as per schedule 3. That is very easy. You all know schedule 3 is mandatory. So the correct option would be option number C. No, not option number C. Option number 1 is incorrect. 2, 3. Option number D. That is all of the above, because I have ticked in each and every sentence. So the correct option would be option number D, and I can see again in this question most of you are correct and very very good. Chalo. So you have learned so much in this class, and let's move to the 9th question. But okay, before that, like the session. You haven't liked it, I think. Yeah, just like the session, everyone. Yeah, very very good. Chalo. Let's move ahead with the 9th question. Okay, 9th question says, this we have discussed. Yeah, 9th question says, as per section 203 of Companies Act 2013, a whole-time key managerial personnel shall not hold office in more than dash company. Oh, very very easy question. Whole-time key managerial personnel, na? He should not hold office in more than dash company except in the case of subsidiary company. So basically it is asking, if suppose someone is whole-time director in a company, can he hold the managerial position in any other office if he is whole-time key managerial position? No, he can't, except for the subsidiary company. So the answer would be 1 here. Okay? He can't hold office more than one company. So option number B is correct, and I can see again most of you are correct. See, again the logic is there, na? He's a whole-time director, na? So he is basically involved in day-to-day operations or in the decision-making process. He's giving his time. So if he's going to hold office for more than one companies, then there will be conflict of interest, obviously, isn't it? Right? So he's not the independent director, na? So that's why he's only allowed to hold office for one company. This is the logic. That's how you are going to connect the provision with the logic. Okay, that's how you remember it. Okay, so option number B is correct. Yes, we have discussed that. Now let's come to the 10th question, and I'll see who all are correct here. Now it talks about subsection as well. Don't worry, subsections are not very important in the examination, but I have written it here just because I wanted to make it difficult. Okay, so as per section 161 subsection 2 of the Companies Act 2013, board of the company gets its powers through a special resolution to appoint which of the following director. So as per section 161 subsection 2, okay, guess anyone. I'll not take the name, and I think I have got the answers. Okay, but I'll not say it is correct or not. Okay, let's move and I will tell you the answer. So as per section, see, few of you might be correct here, and yeah, I can see. Okay, I have got lot of answers here. Okay, see, now look at the question very carefully. It says, as per section 161 subsection 2. I'm not talking about as per section 161. If it were only 161, then it talks about additional and alternate director as well. But we are right now talking about only subsection 2. So let's read out the 161 section in detail, then you will know what is the answer of this question. Okay? So this is the section 161, and this is the subsection 2. It says the board of directors of a company, and from this subsection 2 there could be 2 questions that can be asked in the examination, or I can say there are 2 ways in which question could be framed in the examination. One question I have framed for you. Another important question is here that you will know when we will read out this provision. It says the BOD of the company, if so authorized by the articles or by a resolution passed in the general meeting, appoint a person not being a person holding any alternate directorship for any other company or for any other director in the company to act as the alternate director. So it says, with the help of resolution in the general meeting, alternate director can be appointed by the board of directors. But the answer you know now the answer is alternate director, option number C. But the provision says for a director during his absence for a period of not less than 3 months from the India. Very very important question. So it can be asked from you in the examination ki for if in which case alternate director can be appointed. Okay? And this time period could be asked from you. If the director is not available, if the regular director is not available for 3 months, for at least 3 months, It is written na, not less than 3 months. So he should be not available. He should be absent for at least 3 months from India. Then only alternate director can be appointed in place of him. Okay, remember, second question that could be asked from this subsection is this. Subsection is not going to be asked from you, or the section number is not going to be asked from you from this particular question, but the 3-month time could be asked from you. Okay, okay, that's very nice. Okay, now tell me the answer of this question, and whoever is going to watch it in the recorded format, or even if you are going to watch it in the recorded format, this is the homework for you. You have to give me the answer of this question by searching for it. I don't know how you are going to search for it, but you need to search for it, right? And you need to give me answer to this question. Which of the following statement is true? The promoters of every company, the promoters of every public company making a public offer of any convertible securities may hold such securities only in the dematerialized form. So I think this you can guess logically, isn't it? This is very easy, right? So basically they are going to offer their shares to the public, and the question is saying if they are required to hold these shares in the dematerialized form or not, right? Is this true or not? Okay, so I have started to get the answers, but I will not say who is right or not. Second statement is central government has the power to exempt certain class of companies if it considered in the public interest for complying certain provision of 129 of Companies Act 2013. Again, very logical. Central government can prescribe anything, isn't it? Right? Okay. Now, third option says private company can make public offer of shares. So I'm not going to tell you which statements are correct. You have to give me in the comment section, not in the chat section, in the comment section after going through this question very diligently. Okay? Okay, so that's all for today's class. And now we are going to meet in the tomorrow's class, same time 4 p.m. and again we are going to discuss 10 more most important questions from the examination point of view in the Companies Act. Okay? Everyone happy? Now, do you remember some provisions of the Companies Act or not from today's class? From the 10 questions, at least I have framed 20 questions. So now you must be knowing, now you must be having the 20 questions fact with you, isn't it? Okay. Chalo. So I am ending this meeting. We are going to meet in the tomorrow session at the 4 p.m. Okay. Okay, welcome everyone. Chalo, I am ending this. Okay? Take care everyone. Tata.